residential community control. And I think the distance in time between those goes to the fact that he's not the worst of the worst. And that's the second aspect of it. On the facts of the offense, I don't believe they indicate that he was the worst of the worst, both for F3 in general and for more specifically the elements of this offense. He essentially grabbed a purse out of a window. Should he have done it? No. But is he the worst of the worst at the F3 level? We would also argue no.
I'm not sure from the briefs if we could tell exactly how old he is.
I think it's 40s. He had prior juvenile offenses in 93 or something like that, or?
Yeah,
That seems like just yesterday to me, though.
he was 42 at the time of the PSI, so I believe he'd be 43 or 44 now.
Is there anything in the record, back to the state's suggestion that he could have been indicted on a higher degree of felony? Is there anything in the record to indicate that the court took that into consideration?
The court did not indicate that either at the time of sentencing or in their judgment entry that was a factor, but I believe it was mentioned, and I think it did play into crafting the sentence. The other thing to follow up on that the judge in the entry indicated is that 2912, I believe, has a weight and a counterweight. And there was no indication that the counterweight was considered, which is this the minimum required to accomplish the goals of the sentencing statute when you're looking at protecting the public and punishing the offender. If you only look at the weight, I believe every sentence would be appropriate if it's not contrary to law, but there's no indication that that counterweight was considered. And I think that's also supported by the PSI, where they found with none of the more serious factors. So based on that, we believe the 36-month sentence was an abuse of discretion.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Matthew Kern on behalf of Dean Holman, the Medina County Prosecuting Attorney. I represent the state of Ohio in this matter. As Appellant's Counsel has informed you, there is a single assignment of error in this matter. He challenges the imposition of the maximum 36-month prison sentence for his F3 burglary conviction. I'd like to take a little issue, if I could, to start with the applicable standard of review. And I know this has been a source of some contention across the state. I know the Ohio Supreme Court has actually accepted this issue for further review. That's not specifically briefed, so I won't go into that much. But as for the assignment, the standard of review, 295308G2 now specifically repudiates the abuse of discretion standard. It says that the controlling standard of review for sentencing issues is no longer abuse of discretion. It lays out a standard instead, which says that the appellate court's duty in reviewing sentencing issues is to consider whether the record clearly and convincingly supports the trial court's findings. But it does so in the negative. It says, in order to reverse, you must find by clear and convincing evidence that the record does not support the trial court's findings. And the legislature's use of the term findings is actually significant as well, because findings refers to a term of art. It's right, the State versus Foster, the State versus Ballou, and other cases, consecutive sentence findings under 292914C4. Right, but Foster, 109 Ohio State 3rd 1, paragraph 100, paragraph 7 of the syllabus, findings are no longer required for more than minimum, maximum sentences. So in this case, where the trial court imposed a maximum sentence, it was not obligated to make findings in support of that conclusion. It only had to make findings if it was going to impose a consecutive sentence. And now, the legislature in 2011, House Bill 86, has said that the trial court sentence is only reviewable by this court if it is If the record does not clearly and convincingly support, if this court finds clearly and convincingly that the record does not support the trial court's finding, well, if the court doesn't have to make a finding, what is there to review?
So what's the standard?
The standard is the sentence contrary to law? Right, voidness would be the only applicable standard in that situation in the state's view. I recognize that this court has consistently, since the adoption of House Bill 86 in 2011, has consistently referred to the Kalish plurality standard. My argument in response would be that Kalish was obviously decided in the mid-2000s. House Bill 86 specifically supplants that decision, and the General Assembly had that authority because the Kalish plurality was an interpretation of 2953 in the sentencing review language. In changing the language, the General Assembly could change the result.
And I know this is not the issue necessarily before us right now, but if what you're hypothesizing is correct, that the only thing we would be reviewing here of Mr. Colburn's is whether the sentence is contrary to law, how would that even be constitutionally permissible?
I'm sorry, I don't follow.
Well, all we would be looking at is if it fits within the parameters that the legislature set. So really, there's no meaningful review of the sentence, is there?
Well, I think that there would still be an argument that you would still have the traditional proportionality reviews. You'd still have some argument if the court clearly considered something that it was just constitutionally not entitled to consider, if it was relying on inherently unreliable factors, if it was not considering a pre-sentence investigation report before imposing a community control sentence, right? All of the other things that the legislature has built into other statutory provisions or other constitutional protections in terms of disproportionate to the offense or other things that the courts have recognized, I think those would still potentially be valid bases for review. But the General Assembly can control the court's authority to determine and to review and determine cases and controversies within reason, right, as long as it does not violate any specific constitutional provision.
And that's what I was just going to say, and according to the separation of powers, we can find that unconstitutional as well, so we can go around and around on that, but regardless, so we understand, I think, your position.
Sure. I would say even if the court were to apply abuse of discretion review, it is pretty clear from this record that the court considered things it was entitled to consider. It did not abuse its discretion. Mr. Colburn, Mr. Buchanan concedes in his opening brief that the sentence is not contrary to law, so you only have abuse of discretion review if you adopt that viewpoint. In this case, you know, the state's brief at the bottom of page 12, all of page 13, and all of page 14 contain Mr. Colburn's prior felony convictions. I counted them as I was sitting here this morning. There are 13 prior felonies, many of which were theft, identity theft, fraud, and the misdemeanors are misdemeanor thefts.
This is all related to drug problems, right?
It appears that this is all part of a long-standing drug.
And I know we have the PSI in front of us. And I'm sure it's going to relate treatment that he's received over the years.
Attempts, I think, would be a generous way of describing that, yes. But, you know, I'm sympathetic to the understanding that this is probably the outgrowth of a substance abuse problem. But, you know, at some point, misdemeanors, felonies, the courts repeatedly have tried to get Mr. Colburn the help he apparently desperately needs. It didn't work for either, you know, his reluctance to participate or the shortcomings of whatever treatment program he was in. That's not in the PSI. But repeated efforts at substance abuse treatment, frankly, the only thing left was incapacitation. And in this case, you know, there's an argument about, well, the state's sentencing argument is that he could have been indicted and convicted on the second-degree felony. That is true because the people in the house were either present or likely to be present at the time. So it would have been a valid F2 burglary. And secondly, this court has previously held last year in State versus Assefi, cited in the state's brief 2014 Ohio 2510, paragraph 8, that sentencing courts can consider any relevant sentencing factor. It does not have to be specifically provided for in either 292911, 292912, or any of the less serious, more serious, recidivism more likely, less likely factors in 292913. If it's a relevant sentencing factor that would affect the trial court's sentencing decision, positively, negatively, the trial court can consider it. And I guess the rejoinder to Mr. Buchanan's argument is, if we were strictly limiting trial courts to those things specifically enumerated in the sentencing statutes in Ohio, 292911, 12, 13, 14, etc., there are a lot of things defense counsel would like sentencing courts to consider that are not in there. It works both ways. The defendant had several priors. He used a ruse to commit this offense, and frankly, the trial court ran this sentence concurrently with the Richland County sentence. So he's actually getting credit for 9 months that he really might not have otherwise received. He's really doing, math is not my strong suit, 36 minus 9,
That's why we went to law school, right?
right? 27 extra months beyond his Richland County sentence as opposed to 36. The trial court was not.
My understanding is that the state did recommend that sentencing for consecutive sentence.
Well, our position was incapacitation.
I'm just wondering because he pled to the indictment. I was just a little
And I think
surprised
that
over
was,
that.
I think that was more of we would have been empowered before the case resolved to maybe ask the grand jury to reconsider that decision. I think we gave the defendant some consideration up front in terms of the F3 versus the F2, and if he was intent on not taking that agreement, that we would eventually reconsider our options. I really, that's not obviously in the record, so I can't speak to that more intelligently. As the court knows, I almost exclusively do appeals post-conviction matters. So I can't speak to that more intelligently, but that's my understanding of how office decisions are regularly. Unless the court has any additional questions, which I'd be obviously more than happy to answer, I would ask the court to affirm.
Thank you.
Thank you very much.
We would just note again that we are asking the court to review this under the Calish standard, which we believe is appropriate. We believe the state's construction of the standard under the laws they describe it containing both the findings as a term of art as well as a strict reading of the code would result in an unconstitutional non-review of sentencing. I believe that that would be a violation of my client's due process rights. The second thing I would like to note is that the F2 is not true as to the record, because the record only contains what my client pled guilty to as to the elements of the burglary offense and not the upgraded offense of the F2. If he had pled guilty to an F2, the F2 would be in the record. It's the F3 that's in the record. That's what is appropriate to consider as true at this point. And lastly, as to the fact that these were ordered concurrent, I think if anything that supports our case because the structure of the findings required for concurrence was not there. The judge did not find the required findings for a concurrent sentence, so I believe that indicates they also were not there for the maximum sentence, because if this guy were the worst of the worst, the consecutive factors would have been there as well. We have nothing further. You have any questions?
No, I don't believe so. Thank you both for your presentations. The court will take the matter under advisement and send you a written opinion.
Thank you, Your Honor.
And you can also look on the website.